Good evening and welcome to the Prince Live. This is Debayan, and we are today going to discuss whether a mediation process can resolve the Ayodhya dispute or not. Just to give our viewers a little bit of recap to what happened in the Supreme Court today. In the morning today, the five-judge Constitution bench led by the Chief Justice of India, Ram Janmabhoomi, said that they produced through the answers which they had received from all the parties on their tentative deadlines by when the arguments would be roughly getting over in the case, and the CJI said that we would try our best to wrap up the arguments by October 18 in the case. And now, just to make it clear that on August 6th, it was Nirmohi Akhada who started arguing for one of the Hindu parties in the case, and since then, it's been 17 days since the Hindu parties argued. Thereafter, senior advocate Rajiv Dhawan and Zafar Abjilani started arguing for the Muslim parties, and currently, senior advocate Rajiv Dhawan continues to make submissions for the Sunni Waqf Board. It's also very important to note here that the Supreme Court has said that they have to sit even extra hours every day with the Monday to Friday hearing. They even extend it up to an hour every day. And also he's looking at a possibility of having those hearings on Saturdays as well. Now, if you all remember, it was really path-breaking for the Supreme Court to have Monday to Friday hearings in Ayodhya, because Constitution Bench hearings usually happened from Tuesdays to Thursdays, because Mondays and Fridays usually were allocated for miscellaneous matters. But however, since this matter was gravely important, hence all these days were allocated to the same. Another issue which also becomes very important is November 17 is when the Chief Justice of India, Ranjan Gogoi, retires. So when if he retires on the 17th of November, it becomes imperative for the Chief Justice of India to deliver the verdict before he retires. And if in case that does not happen, that essentially means that the entire hearing that spanned over almost 60 odd plus days will prove to be a waste, and entire proceedings in the entire hearing has to resume again under a fresh Chief Justice of India or with a new judge in the five-judge Constitution bench. However, that situation is highly unlikely to happen, because the Chief Justice has made it clear that they need some time to, of course, write down the verdict. If you remember, when the arguments for this case started, then senior advocate Rajiv Dhawan made a very important submission saying that I don't think that any of the judges on this five-judge Constitution bench would have read the entire verdict given by Justice Aftab Alam and his brother judge by the Allahabad High Court in the case in 2011. And he said that it was only perhaps Justice Chandrachud who has read the entire verdict. So you would, with this statement, you have a fair idea as to how voluminous the verdict was in 2011, and the appeal thereafter filed will also have to be more and better reasoned in that case. Another very important development which took place today morning was the Justice Fakir Muhammad Khalifullah led panel was leading the mediation proceedings in this entire case, and it is now that again the panel has written to the top court saying that there is a chance of mediation being resumed. However, the court has now said that since the hearings are at an extremely advanced stage, let's note this point very clearly, since the hearing is at a very advanced stage, there is no possibility of scrapping the hearing at the moment, and the mediation process, which was a confidential affair, can go on simultaneously. However, if they reach a solution in the mediation process, then they can intimate the court. Now, since today we are essentially discussing can mediation be successful, let me just clarify two particular things with our viewers. In the month of July this year, when the court was wondering as to what would happen to the deadline that it had set in March of 30th July for the mediation panel to submit its report. At that juncture, the court realized, after asking for an interim report from the mediation panel, that a solution in this case was highly unlikely, and that is why from 6th of August, the day-to-day hearing in this case had begun. But now, just to give you a little bit of lowdown on how the mediation process works, here Justice Fakir Muhammad Khalifullah, Sriram Panchu, and another mediator, Shri Ravi Shankar, all these three people would be on the board to decide whether all the parties are on board or not. Now, mediation is a very peculiar sort of affair where even if there are 40 parties in a case, I'm giving a very hypothetical example, even if there are 40 parties to a case, even if one party takes a back seat, okay, and they do not want to be on board for the mediation process, at then and there and that point of time, the mediation process fails. Unless and until that party is on board, the mediation process cannot go on. Sources, all the information that we get through is purely sources when the mediation was kept strictly under wraps. So, sources have told us that there are two roadblocks to the entire mediation process. To be very clear, one was Mr. Arshad Madni, who belongs to the Jamiat Ulema-e-Hind faction, and one was Ram Janmabhoomi. Both these parties have made their stands very clear that they would not agree to a settlement in which the mandir or the masjid would have to be compromised. So these two roadblocks could not be erased by the mediation panel, and that is why perhaps the mediation settlement could not be reached at. However, just 2 days on the 5th of September, in fact, the UP Sunni Central Waqf Board, which is in fact a government institute, had written to the mediation panel saying that the mediation proceedings should be resumed in the case because there is a hope that people would be on board. And since parties are also inclined for mediation to begin, we would realize that indeed there could be some hope, and the parties are perhaps realizing after this 27 days of arguments in the Supreme Court that maybe a judgment in this case would not be that favorable to all the parties concerned as much as compared to a mediation proceeding. Let me just quickly glance through if we have any questions. Yeah, one question is, does the force of limited time for negotiation affect the outcome of the earlier negotiation? And what were the grounds which led to the failure of the deal? So the grounds I have just told you, but again, to be very specific with you, Mr. Yadav, those are completely source-based information. On official record, there is nothing because, of course, the entire process of mediation was under wraps due to the confidentiality clause which was put on by the Chief Justice of India, Ram Janmabhoomi, and hence the Supreme Court cannot take a official, the press cannot take an official call on the what the sources have said as per what happened or transpired in the mediation proceedings. But these two factions which I just mentioned, Mr. Arshad Madni of Jamiat Ulema-e-Hind and the other player of Ram Janmabhoomi, indeed proved to be a roadblock. Now, the second part of your question, does the force of limited time, see, of course there were murmurs in the court corridors also that the deadline of 30th July hanging on the head of the mediators proved to be kind of a roadblock in reaching a permanent settlement head. So you would appreciate the fact that this time the Chief Justice of India has said that there be no time limit to the mediation process. So you would realize that today it is the 18th of September. From the 18th of September till he retires to 17th of November, he has time to complete the hearing and deliver the verdict. In that particular case, in that particular scenario, the mediation process will have to go simultaneously with the court proceeding. When it was ordered in March, there was no hearing going on, only mediation process was there. But however, this time the court has inclined that since it's an advanced stage of hearing, they cannot junk the entire hearing which has taken place, and hence mediation has to go on simultaneously. So I don't think a point of limited time this time would prove to be a dampener in the entire process. There's another question from Mr. Shanu. What will happen if the land will be distributed between both the boards? So, Mr. Shanu, very interestingly, in 2011, when the Allahabad High Court gave its verdict, it had distributed the one-third of land between the three primary parties in this case. However, now if we look at the arguments closely, which the print has been tracking very closely in the courtrooms, courtroom number 1 of the Supreme Court, firstly, the Nirmohi Akhada has claimed spiritual rights over the disputed side. It has said that they worship at the place. They have the Shibaite rights over the place, and that is the particular claim of Nirmohi Akhada. Whereas Ram Janmabhoomi says that the entire area, let us understand this, the entire area where Lord Ram had taken birth in Ayodhya is a juristic person. In essence, the Hindu parties argue that if there's a place A where Lord Ram had taken birth, then B, C, D, E, F, G, all the other areas which are surrounding the area is also as holy as compared to the site A, which is cited by the Hindu parties. So they are putting forward an argument that the entire area where the masjid was built is in fact a juristic entity, and it needs not be proven that the exact spot which is right down the dome of Babri Masjid was in fact the place where Lord Ram had taken birth. So that is one of the very primary contentions of the Hindu parties in the case. They're also mentioning that all the emblems of gods and goddesses on the 14 Kasauti pillars, which holds the the Ram Chabutra or the Babri Masjid inner dome area, squarely prove that Islamic prayers could have never been conducted there, because in the presence of images of gods, goddesses, or animals, etc., Islamic does not permit prayers, because there is a concept of in Islam wherein the figures and animals and male, female, drawings do not allow a person to pray in that particular spot. So that is another argument by the Hindu parties. However, senior advocate Rajiv Dhawan has squarely dismissed all of these pleas on behalf of the Sunni Waqf board. They have squarely argued that all the emblems that the Hindu parties have shown in all these 14 Kasauti pillars were nothing but of lotuses, etc., and it had no idols of gods and goddesses. And in fact, it goes on to argue that the Hindu parties have the onus on them, or the liability on them, to show that in fact there were presence of idols and of gods and goddesses in the 14 on across the 14 Kasauti pillars inside Ram Janmabhoomi or the Babri Masjid. Another argument by the Hindu parties were also that this Babri Masjid was also called as Janmasthan Masjid. So one of these arguments also say that since the place was known as a Janmasthan Masjid, it is apparent from the name that it was perhaps Janmasthan before, and then it came to be known as a masjid when whoever Babur or Aurangzeb destroyed it and built a new temple there. So these are the key arguments that is happening in the case. So just to answer your question, that what will happen if the land is distributed within the board, so these are the particular issues that will come up if the land is distributed between the board, because all of the parties are wanting the land, are demanding the entire land for their own particular use. And the special thing about this case is the case has landed in appeal against the 2011 verdict is only because the land was distributed, because this was not a part of the prayer that was made by any of the litigants in the case. Whether it be the Hindu parties or the Muslim parties, none of them prayed to the court that the land be equally distributed if a settlement is not arrived at. So that is also one of the grounds of appeal, that the High Court had delved into an area which was not its domain to delve into, or they did not have jurisdiction to entertain. We have a question from Ms. Rajni. The Vishwa Hindu Parishad has said some people are using tactics to cause delay when mediation has failed. Why do they want to go back to it? They are saying it will be the favor. Your comments. So, Ms. Rajni, to answer you very in very brief. Leaving aside what Vishwa Hindu Parishad said, it's an organization, it has made an independent statement, but let's not confuse that statement with what's happening inside the courtroom or what's happening in the mediation proceeding. Again, to give you a bird's eye view, mediation proceedings and the court's hearing will be happening side by side. So there is no intermingling of affairs. If the mediation panel decides by November beginning or October end that there is no settlement to the case, that will have no bearing on this case, which will likely wrap up by October 18, and the verdict would likely come before the Chief Justice of India, Ranjan Gogoi, retires on November 17. However, let's remember that if in case a settlement is arrived at as per the rules and procedure of mediation proceedings in India, the 5-judge constitution bench has to be intimated by Justice Kalfulla-led committee that indeed a solution has been reached onto, in which all the parties are on board, and then the parties will explicitly give a consent to junk all the hearing that has taken place and accept what solution has been agreed upon by them in the mediation proceeding. So that's how it works, and that's how it's going to work in this case also. Mr. Muhammad Iqbal asks me, mediation panel dissolves ipso facto after it submitted its report to SC. Why again the plea? So Mr. Iqbal, this mediation panel has again come into light because the parties themselves have written to the mediation panel that there is again a chance for mediation perhaps, and they would be forthright in putting forward the submissions before the panel, and they indeed see a ray of light in resolving this dispute mutually. Let's not forget that this dispute dates back to centuries. Now when these arguments are happening in the court, there are scriptures and the drawings which are being referred by the 5-judge constitution bench, which at times the judges cannot even decipher from the images that are being presented to them on the bench. In fact, yesterday there was a discussion on an emblem of which had 2 lions, So the image was so hazy that both of them, all the judges were confused as to what exactly to make out of it. So senior advocate Rajiv Dhawan said that this emblem needs to be enlarged to, order to understand what it is. However, he said that it is indeed an Islamic design or a king symbol. However, the Muslim Hindu party said that it is a sign of Garud, or it says Garud emblem. So you would see that since the evidences date so back in history, that each of the parties are able to draw some conclusion from the same evidences that are being presented to the 5-judge constitution bench. So let's understand the complexities of this case involved here, and hence the mediation proceeding was considered as one of the viable options in this case. If you remember, even the then former Chief Justice of India, Justice J.S. Kheher, also suggested that take some, give some, and resolve the dispute of Babri Masjid through a mediation or negotiation. And he said that I am also willing to be a mediator in the process to help you all come on board and reach a conclusion. So that is why the Chief Justice of India did not outrightly reject this submission by the Justice Fakir Muhammad Khalifullah led mediation panel, and has in fact given them a second chance to conduct the mediation proceedings. However, the court proceedings will not be hampered. Today was the 27th day of hearing, and it will go on as per schedule till October 18, till all the parties' rebuttals, counter arguments are over. We have a question from Mr. Paul. What will happen if the decision not going positive to Ram Mandir? Mr. Paul, that's a very speculative question for us to answer here at The Print. What will happen if the decision is not in favor of the Hindus, or decision is not in favor of the Muslims? What we can easily tell you is that whatever happens will happen within the bounds of law, and what the judiciary decides within the conscience of their understanding of the legal book or the evidences placed before them. And if in case there is a dispute with the court's verdict, there is indeed, there are options of filing review petitions and curative petitions with the petitioners, whoever stands to gain or lose in this case. So that is something we have to wait and watch. If you are implying to connect certain dots politically in this, then let me tell you that indeed this case has extreme political overtones, with Vishwa Hindu Parishad making statements, with All India Muslim Personal Law Board making statements. So all of these parties have indeed certain stakes in this entire matter, and it will indeed be blown out of proportion when the verdict will be due from the top court. However, it is our duty not to mix the court's verdict with politics and keep both of them aside. Mr. Shivas asks me, is Sunni board trying to delay this proceeding? There are certain belief, some segments that indeed Sunni Waqf board is trying to delay the proceeding, because Senior Advocate Rajiv Dhawan made a very peculiar submission before the court that he cannot argue continuously for 5 days and he needs a break on Friday. So that's why last Friday there was no hearing. However, the Hindu parties, when Senior Advocate K. Parasaran or etc. were arguing, they did not seek any such kind of adjournments or privileges, and they kept on arguing for all the 5 days. So that is one particular place which has given rise to these conversations that Sunni Waqf board is looking at a delay, and the mediation process is being kick-started to only proceeding. But again, we are making it clear the process would be continuing simultaneously, side by side, and hence there is no question of delaying either of the process. So I think that's all we have for today. I have also given a lowdown on the arguments that are taking place in the court in the case. We also approach the 28th day of hearing tomorrow, and we at The Print will keep you updated with all the events that is happening with this historic Ram Janmabhoomi Ayodhya hearing. Please subscribe to our channel on YouTube and like us on Instagram, Telegram, Twitter, Facebook, etc. and keep watching us for more updates. This is Debayan Roy for The Print.